Okay, I wanted to start this lecture on the presidency by reading a little something from Federalist Paper number 67. It's good. It's as follows. There's hardly any part of the system which could have been attended with greater difficulty in the arrangement of it than the executive branch. And there is, perhaps, none which has been inveighed against with less candor or criticized with less judgment. Here the writers against the Constitution seem to have taken pains to signalize their talent of misrepresentation. Calculating upon the aversion of the people to monarchy, they have endeavored to enlist all their jealousies and apprehensions in opposition to the intended President of the United States, not merely as the embryo, but as the full-grown progeny of that detested parent. To establish the pretended affinity, they have not scrupled to draw resources even from the regions of fiction. The authorities of a magistrate, in few instances greater, in some instances less, than those of a governor of New York, have been magnified into more than royal prerogatives. He has been decorated with attributes superior in dignity and splendor to those of a king of Great Britain. He has been shown to us with the diadem sparkling on his brow, and the imperial purple flowing in his train. He has been seated on a throne, surrounded with minions and mistresses, giving audience to the envoys of foreign potentates in all the supercilious pomp of majesty. The images of Asiatic despotism and voluptuousness have scarcely been wanting to crown the exaggerated scene. We have been taught to tremble at the terrific visages of murdering janissaries, and to blush at the unveiled mysteries of a future seraglio. Well, I don't think the prediction about a seraglio turned out to be true. But the question we'll have to consider is this. In some ways, weren't the opponents of the Constitution correct? Was there something imperial about the institution of the presidency from the very beginning? Some scholars would say that the presidency was not intended to have this imperial character. It was not intended to be the dominant institution of the national government, but they would say that nevertheless, this is exactly what happened. There are many, many examples of this, but one of my favorites is by Matthew Crenson and Benjamin Ginsberg of Johns Hopkins in a book called Presidential Power Unchecked and Unbalanced. And their basic claim is that sometime in the 20th century, the American political system moved from a Republican form of government to what you might call a presidentialist form of government. It's just another term for an imperial presidency. So what are the main signs of the imperial presidency? When people talk about this growth in presidential power, what are they talking about? Well, it seems to me there are four main categories, four main dimensions to the imperial presidency. The first, we can think of it as the president's role as a public leader. Someone who claims a mandate to lead the public, perhaps someone who claims a mandate to transform the nation. The idea here is that the president, the modern president, claims to embody the general will, as opposed to simply being the servant of Congress, the protector of the Constitution, the person who's responsible for enforcing the law. According to critics of the modern presidency, this notion of the president as public leader, embodiment of the public will, distinguishes the modern presidency from the constitutional presidency. Second category, the power of the president in the legislative sphere. And here we're talking about the ability and the tendencies of the presidency to play a major role, not merely in executing law, but actually in creating law. So the notion here is that the modern presidents have become legislators in chiefs. They're no longer simply executing the will of Congress, but in fact they attempt to direct Congress. They try to control the legislative process, or at least set the legislative agenda. Third category, the power of presidents to alter policy unilaterally. We'll talk about this in significant more detail, but the basic idea here is that the structure of the modern state allows presidents to change the meaning of law without having to go through the complicated legislative process and checks and balances and all the hurdles that legislation has to go through. The key notion here, and something we'll talk about more, is the idea of delegation of legislative power. Congress has granted so much discretionary power to the presidency that really the president determines the meaning of law. and policy changes independently of any changes within that are created by Congress. So this power was not anticipated the by the Constitution. Bad enough that the president interferes in the legislative process, but the modern president is distinct from the constitutional president because they can change the law without even having to rely upon Congress. Finally, there's the power of the presidency in regards to foreign policy. Congress, or according to this argument, Congress has simply abandoned its role in foreign policy and in many cases even in regards to security policy. So, you have all these different aspects of presidential power. The president as public leader, the president as legislator-in-chief, the president as bureaucrat-in-chief, and the president as foreign policy czar. And this leads to the conclusion that the presidency that exists now is different from the presidency created by the Constitution. The Constitution, in other words, did not attempt to create an imperial presidency. Well, I think that conclusion is only partially correct. I think that the formal powers of the presidency, the powers spelled out in the Constitution, are immense. In particular, the Constitution does not tell us very much about the precise public or political role that's played by the presidency. It's similar to the fact that Congress, or rather the Constitution, assigns certain powers to Congress, but it doesn't determine exactly how the House and Senate arrange their internal business. That's something that they're able to determine on their own. Well, the precise public or political role of the president isn't determined by the Constitution either. So from my perspective, and I'll try to argue, is that the role of the president as a public leader and the role of the president in the legislative process are perfectly compatible with the forms established by the Constitution. It's not that the Constitution requires the president to play those roles, but the Constitution says nothing about the president's role as a public leader or role in the legislative process. The power of the president to make unilateral policy, or to make policy unilaterally, is, I think, far more troubling. There are several different causes of this. I think the most important are associated with changes in American federalism, or what you might think of as the breakdown of the legitimacy barrier. If you want the national government to be involved in a whole host of policy fields, as opposed to simply the very limited number of policy fields discussed by the Constitution, then unavoidably you are going to have a larger role for the executive branch and a larger role for the presidency. The case of foreign policy is rather different. Here, it's not like in domestic policy where it's essentially Congress, given the demands of public opinion, Congress has to delegate power to the executive branch, and in many cases simply has to delegate discretion to the executive branch. The case in foreign policy is simply that Congress has chosen, in many instances, not to restrain the presidency when there's no absolute reason it couldn't assert itself more aggressively. But perhaps the differences are not so stark. The basic idea here is that if you want to have a national government that's going to be, regulating a vast number of, say, products, whether pharmaceuticals, food, and so on and so forth, you're going to have to give a lot of discretion to the executive branch. Congress probably cannot make all the rules. Perhaps on the foreign policy side, you have a similar problem. If you exist in a world where the distinctions between war and peace are in many cases difficult to discern, then perhaps you're going to have to grant a lot of discretion to the presidency as well. I think what typically happens is that those on the left look at domestic policy and say, yes, of course, it's necessary for there to be a great deal of discretion in regards to policy making just because of the complexity of the modern world. But they say, well, foreign policy isn't as complex. There you can have a greater role for Congress. Those on the right wing of the political spectrum tend to see things in reverse. What this comes down to, however, is that the real constitutional changes in American government are not so much in the presidency as they are in Congress and particularly federalism. Congress changes the way it legislates, or changes, or in some cases, the way it chooses not to legislate, and this creates the appearance of presidential power. But what's really happened is that the form of the presidency remains the same. It's just that Congress has pursued its own duties in a different way. And hopefully, by going through some of the formal powers of the presidency, we can see why this is the case, why certain aspects of the modern presidency are very much in line with the Constitution. And even in those areas where presidential power has grown immensely, it seems to have grown immensely, the constitutional changes really emanate from Congress. They're not something that's simply asserted by the presidency. Okay, if you are following along on the Prezi, move to Prezi 2 now. The Electoral College and the rise of the personal presidency. The notion of the personal presidency is one way to distinguish the modern presidency from the constitutional presidency. And the idea here is that the personal presidency is meant to embody the public will in their person. It's a notion that's familiar to us. It's the idea here is that the president as a person is not simply an officer of the Constitution. It's not merely someone who's subordinate to Congress, but rather is someone who is a public leader, who in some sense embodies the public will. That the president is not merely the chief executive, but in some ways a representative of the nation as a whole. Now, in some ways, this seems to depart from the constitutional understanding of the presidency as it was originally envisioned. And this is for a reason that we're familiar with. If we look at the Electoral College and the discussion of the Electoral College in the Federalist Papers, and such as Federalist Papers number 68, we see that even though the people were meant to play a role in the selection of the presidency, they were not meant to play the only role. The people were meant to choose the electors who would select the president, but in that sense, the president was not being chosen as a representative of the people so much as he was being chosen for his abilities or potential abilities as a chief executive. Now, the thing is, of course, is that this mode of selecting the presidency was never really put into practice, or at least it didn't last in practice for very long. What happened is that electors pledged themselves to political parties, essentially eliminating their independent role in selecting the president. And therefore, almost from the very beginning, probably from 1796 onwards, the president became a partisan representative figure. From the very beginning, then, the president could, in some ways, claim to represent the political nation. The connection between the president and the public, perhaps it could have developed in a different way. Perhaps it could have developed in the way that was initiated by Washington as a president who transcended parties. But for whatever reason, probably simply because of the democratic temper of the nation and the democratic temper of the times, that notion of a simply dignified, apolitical institution, that did not last for very long at all. So as a consequence, the Constitution really doesn't tell us very much about which national institution should be regarded as the embodiment of the public will. It doesn't tell us when a victory in the Electoral College should be regarded as more significant than a victory in congressional elections. It doesn't tell us whether a president is allowed to claim some kind of electoral mandate or Congress. It simply doesn't tell us anything about how the president should relate to the public. So, as a consequence, this notion that the connection between the president and the public represents a constitutional change is, I think, misguided. On the one hand, it's the relationship between the president and the public has been transformed by technology. Presidents in the early 19th century simply didn't have the ability to communicate with the public. They didn't have much ability to move around the nation. So as a consequence, campaigning becomes more national in scale, not because of any departure from the constitutional order, but simply because the possibilities for campaigning are now expanded as a consequence of technology. And again, this is something that happens well before, say, the New Deal era. It's something that is a pretty constant process heading through much of the late 19th century. So in terms of the question of how the relationship between presidential selection and the relationship between the president and the public, I think it's pretty clear that the Constitution doesn't establish one mode, right? It's possible for presidents to see themselves as not necessarily being public leaders, as not necessarily having an incentive to be shapers of public opinion. But at the same time, the Constitution doesn't prevent that. You might say that the Constitution has a considerable degree of flexibility in terms of how the presidents comport themselves in relationship to the public. So, changes in the modes of presidential selection through the Electoral College. The changes that occurred at a very early stage. The modes of presidential selection were politicized. They became partisan at a very early stage. And the changes in presidential campaigning and the related changes in presidential communication, and thus the changes in the relationship between the president and public opinion, those are things that, of course, are enabled by technological change, not by any fundamental constitutional change. But what about the other powers of the presidency? The question here is whether the exercise of executive power has, over the course of the 20th century, burst the bounds of the Constitution. Now, to consider this question, we have to ask two related questions. What kind of power is granted to the presidency through executive power, and how or has it changed at all? The first question is in some ways easy to answer. The president, by the terms of the Constitution, has been granted the executive power, though it turns out the president, of course, has also been granted legislative powers, but we'll turn to that later. The Constitution says in Article 2, Section 1, Clause 1, the executive power shall be vested in a President of the United States of America. And that is basically all it says about executive power. This is very much in contrast to the much more detailed description of Congress's legislative power. So what has been granted to the presidency through the so-called vesting clause? What does it mean to vest executive power in the presidency? Well, one way to approach this is to say that, well, according to the Constitution, quite clearly the president is simply given the power to execute the will of Congress. And therefore, the more independent power of the presidency that develops over the course of the 20th century is very much a departure from the constitutional structure. You might call this the clerk-in-chief theory. The president is just a clerk, not particularly important. The other alternative, following the language of Alexander Hamilton in the Federalist Papers, is one we can call the energetic executive theory. And according to this conception of executive power involves more than simply enforcing law. Even enforcing the law requires a considerable degree of discretion. As we'll see, that discretion about how to enforce the law becomes increasingly significant as the national government becomes more expansive. But just as importantly, there are many kinds of presidential actions that cannot be understood as law enforcement. So on the one hand, enforcing law simply involves setting priorities. And as I said, this becomes particularly important in the 20th century, though it would have been important at earlier stages as well. Enforcing law costs money. Therefore, presidents have to establish their priorities in terms of what kinds of laws they're going to enforce and what kinds of crimes they're going to prioritize. And in this way, presidents are no different than police officers, who are also a kind of executive official. No police officer simply enforces the law. It's more accurate to say that police officers decide what laws to enforce and when. Any police officer who ruthlessly prosecuted, any violation of, say, traffic laws in Toronto, would soon be told to tone it down. They'd probably lose their job. Actually, it's almost impossible for a unionized police officer to lose their job. But anyway, you know what I'm talking about. In practice, no police officer simply enforces the law. They ignore a great deal. Presidents, in some ways, have to perform the same function. Obviously, President Obama is not out on the street enforcing the laws, but they will set priorities, and there's going to be a considerable degree of discretion in terms of what kinds of laws or what kinds of issues they're going to pursue. The number of laws, essentially, are always out of balance with the resources available to enforce them, and presidents necessarily play a huge role in deciding how to use those resources to enforce law. Now, we'll turn in a few minutes to a related and more problematic question of whether the unavoidable discretion about how to enforce law can turn into a kind of presidential policy making. And I think that is a slightly different problem. But now we have to address another problem with executive power. And this is the idea that executive power includes not only the power to determine how to enforce law, but even the power not to enforce law, and even the power to violate the law, and perhaps even the power to violate the Constitution itself. This way of thinking about executive power is based on the notion that presidential power includes prerogative power. And this is basically the basic theoretical premise of prerogative power was articulated by the philosopher John Locke, and it's relatively easy to explain. The idea is that there must, within any political order, there has to be some institution that has the power to preserve political society. And the power of that institution can be used in certain extreme circumstances to violate the law in order to preserve the framework of legality as a whole. In other words, law is a means. Law and legality are not ends in themselves. The purpose of law within a Lockean framework, a classical liberal framework, is to preserve life and liberty, and it would be absurd to treat what is merely a means, lawfulness, as an end in itself. All right. And then we can see right away that makes a certain amount of sense. It doesn't make too much sense to adhere to every last letter of the law if by doing so you're going to be conquered by Nazi Germany and then suddenly have a completely tyrannical form of government. But at the same time, we can also see the potential danger of thinking in those terms. Sure, there might be extraordinary situations. There might be exceptional situations. But the political leaders who decide on the exception might easily come to regard a very broad range of situations as exceptional, and therefore situations where they're not bound by law. It's a dangerous idea. However, we should see that this problem of prerogative, this tendency to push presidential power beyond the limits of the law, is not a peculiarly modern 20th century, 21st century problem. It's always been there. Perhaps not to the same, or not with the same frequency, but it has always been there as a problem. A few quick examples. Jefferson's Louisiana Purchase. Thomas Jefferson was a strict constructionist, yet at the same time, he believed it was acceptable for presidents to violate the Constitution in extreme circumstances, not only to prevent great evil, but also to achieve significant good. Now, he didn't think that therefore the president's actions were lawful. He just thought, simply as a matter of logic, that there can be situations where the interest of the country, the public good, demands exceptional actions by the president. And the Louisiana Purchase was an example of this in some ways. What was the Louisiana Purchase? The Louisiana Purchase was basically a situation where the United States purchased a huge body of land stretching from New Orleans to the Canadian border for $15 million from France. The interesting thing was that though this occurred under the auspices of Thomas Jefferson, Jefferson, for some strange reason, did not believe that the national government had the power to incorporate new territory or to grant citizenship to aliens. I think that this is almost certainly a mistaken constitutional interpretation, but that's what the president believed, and he went forward rather with the purchase anyway. And also interestingly, he basically didn't promulgate the fact that he had all these constitutional concerns about the purchase. So here we have an instance where, from the very beginning, presidents have acted in ways that they knew to be illegal. And it was with this background understanding that, well, of course, there can be some circumstances where quick and decisive action are going to be necessary. Basically, Jefferson thought that if he made his constitutional concerns public, it might have scuttled the whole deal in one way or another. Now, moving forward to the Civil War era, we have perhaps in some ways an even more serious example of presidents acting, in this case in an emergency situation, acting in ways that violate the law. And again, in these situations dealing with Lincoln's violation of the law, it's justified on the basis of public necessity, though there is some room to quibble here, I suppose, as to the question of whether or not Lincoln actually violated the law during the Civil War. So what actually happened? What happened during the Civil War is that Lincoln violated, or rather suspended, the privilege of the writ of habeas corpus. What is the writ of habeas corpus? It's basically a petition to a judge in which you petition the judge to say, explain to us why a person has been detained by the authorities. The Latin means something like produce the body. And the basic idea is that, yes, you bring the person forth and then the government has to explain why they've been detained. So, Article 1, Section 9 of the current Constitution states that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. So, this is what happened. In 1861, in the midst of the Civil War, actually at the beginning of the Civil War, the writ of habeas corpus was suspended in the D.C. area. Now, Washington, D.C. is surrounded by Maryland and Virginia. Virginia had seceded, and there were a large number of Confederate sympathizers in Maryland at the time. All kinds of acts of sabotage against bridges, against railway lines, against telegraph lines were occurring at this time, and a prominent Democrat in Maryland was arrested after various acts of sabotage. I guess this man, his name was Merriman, found a way to get his lawyers or his friends to bring a writ of habeas corpus to the home of the Chief Justice of the Supreme Court, Justice Taney. However, when this was brought up in court, a military officer informed Justice Taney that Lincoln had authorized the suspension of habeas corpus. Taney ruled that only Congress had the power to suspend habeas corpus in times of war. And Lincoln essentially ignored the decision. Lincoln's position was that a rebellion was underway, created a condition of war, Congress could not be readily assembled, and he just couldn't allow judges to release saboteurs that had been detained by the army. Now, in this instance, it's not a perfect instance of a president ignoring the law in order to advance the interests of the nation, or ignoring the law in an emergency situation. He was merely ignoring a one judge's opinion about the law. And Taney's reading of the Constitution in this case is almost certainly incorrect. The Constitution doesn't declare who can suspend habeas corpus, it only declares the conditions under which it can be suspended. And it was a condition of rebellion. So basically, the country had become a war zone. Lincoln was probably fully justified. The more important question here is Lincoln's claim that, even if he was violating the law, what would be the point of adhering to this law if it meant the entire government was going to be destroyed, and thus the entire Constitution? Should all the laws but one go unenforced? That was basically Lincoln's position. So again, we can see that this problem of presidential power in emergency conditions is not something that only exists in the modern world, however far presidents might have pushed it. It's something that has, emerged, again and again. Perhaps with more frequency in the current age, but it's certainly not unprecedented, rather. We can see then that examples of illegality by modern presidents, as troubling as they might be, are really not unprecedented. It's not to say that they're justified, it's just to point out that this problem of the exercise of discretion in emergency circumstances is one of the recurring problems of political life. Let's go through a few of them. And what we'll also see as we look at some of the modern examples is that in some ways, courts have become, in some circumstances, more willing to use judicial power to restrain executive indiscretion. Now, judicial power isn't always that effective at restraining executive discretion, but it is nevertheless significant. Okay, let's use one example in which the courts chose not to ask their power. And this is the case of Korematsu from World War II, the Korematsu case. You're probably familiar with this. You're probably familiar with the basic facts. After Pearl Harbor, President Roosevelt authorized the military to intern American citizens of Japanese descent on the West Coast. And at a certain formal level, the issue was no different than the situation faced by Lincoln. It's a situation where presidents are claiming that there's an imminent threat for the country being destroyed, or at least fatally undermined, and it's necessary to preserve the public safety. The difference is that, as a factual matter, Lincoln was probably correct, FDR was probably wrong. Now, in the Korematsu case, the majority of the court ruled that the government was simply taking a reasonable step to win the war and ensure the security of the American people. We should note that at this point, if the court had ruled differently, it would sort of been irrelevant. In some ways, the decision didn't matter, because by the time you get to the Supreme Court, in this case, the war was almost over. It was late 1944, I believe. The internment camps were already being shut down. But one of the dissenting justices pointed out a different problem with the majority's position, which was that the majority was basically saying that an illegal action was not illegal because the president was taking it. Right? The real problem, according to Justice Jackson in his dissenting position, was not that the courts weren't doing all they could to stop the exercise of the prerogative power. Jackson's position was that there's in a true emergency, there's literally nothing courts can do to stop presidents. And in fact, courts probably shouldn't direct what presidents do in an emergency action. But what they shouldn't do is claim that actions taken under an emergency are legal. In other words, for Jackson, it was important for the court to recognize, and thus for the public to recognize, the illegal character of the president's actions. There was nothing, Jackson was well aware there was literally nothing he could do to stop the president from doing this if he really thought that the existence of the United States depended on it. But to declare that the actions were legal, because in some sense rational, which probably not, obviously, but to declare that those actions were legal creates an even greater threat than the prerogative power itself, because it creates the potential for illegal actions to be legalized, to be normalized. It creates a potential for the exception to become the norm. So we might think that this Korematsu case shows that in the 20th century, courts are really working to enable the imperial presidency. And we can't go through all of the relevant court cases in an exhaustive manner, but we should just note that, in fact, there are many other signs that the courts, in other circumstances, were really willing to restrain the power of the president to act in emergency situations. Let's just go through a few examples really quickly. One of the most important ones happened just a few years later. I think many members of the courts were still the same. And this is the case of the Youngstown Sheet and Tube Company versus Sawyer from 1952. So this is also happening in wartime, happening in the case of the Korean War, but the outcome was rather different. In 1952, the United Steelworkers of the USA had decided to go on strike. President Truman thought this would affect the war efforts. Truman basically ordered the government to nationalize the steel mills, to seize control of them. In a case brought to the Supreme Court, a majority of the court ruled that the president had simply gone too far. Wartime, the existence of a war, does not justify ignoring the legal framework that exists dealing with labor strife, essentially. Now again, Justice Robert Jackson's concurring opinion was in some ways the most interesting, because what Jackson basically provided a certain kind of common sense framework for considering the scope of executive power. And he starts with a very common sense observation. The scope of executive power is not clear from the Constitution. You can stare at the Constitution all day and all night. It will not tell you the precise boundaries of executive power. So what can the courts do? Well, they have to measure executive power in relationship to what Congress has done. The president's power is going to be greatest if the president's actions are in accordance with either the expressed or implied consent of Congress. If the president is going against the will of Congress in a clear way, then courts have much less reason to defer to the presidency. But in between these two situations, there's going to be a vast gray area. However, Jackson didn't think that there was much gray area in this case. Congress had passed laws governing labor relations. Those laws could not simply be thrust aside by the war powers. I think Jackson might have added that courts could not declare that the president's powers were legal. Jackson well knew that if the president really wanted to do it, there was not much the courts could do to stop him. So we can see here that in this case, right in the heart of the modern era, courts were willing to push back against certain aspects of the imperial presidency. The modern era has not witnessed the emergence of a presidency that's entirely unconstrained by law. In fact, in some cases, and in fact, many other cases, courts are willing to place new, you might call them theoretical limits on the scope of presidential power. Now, we always have to keep in mind here is that courts work very slowly. And in many cases, judicial limits that are placed upon the presidency are merely theoretical. But nevertheless, it is the case that courts have tried to define the scope of presidential power and in some cases placed real limits on it. We'll use two cases from the War on Terror in order to illustrate this willingness of courts to constrain the imperial presidency. The first is Hamdan versus Rumsfeld from 2006. The second, Boumediene versus Bush from 2008. These are just examples of cases in which the courts the courts show a willingness to constrain the executive's power to act in unusual or exceptional situations. Okay, we'll start first with the Hamdan case. Hamdan was a Bosnian who was imprisoned in Guantanamo Bay. I believe he had been arrested by Bosnian police and handed over to the U.S. government. The Bush administration lawyers argued that because Guantanamo Bay was not a part of the territorial USA, that detainees could not have access to the U.S. legal system. Hamdan was apparently Osama bin Laden's driver, and he was tried before a military tribunal in Guantanamo. But his lawyer was able to make a habeas petition to the federal courts in the United States, and his lawyer argued that this trial by military commission that he was given in Guantanamo was unlawful. And in this case, the lower federal court judge agreed. Eventually the case makes its way to the Supreme Court, and the Supreme Court rules for Hamdan. The Bush administration had to follow the regular procedures for military commissions that had been established by Congress. So in other words, a decent example of the fact that courts are willing to constrain executive discretion in foreign affairs, though at the same time we should note that the number of cases that are making its way through the courts are in no way equivalent to the number of potential cases that are out there, the number of potential people who are being detained by the government in who knows which parts of the world. Now, the Boumediene case is interesting as well. Boumediene, unlike Hamdan, had been held in Guantanamo Bay for 7 years without any kind of trial. Was he the person who was actually arrested by the Bosnian police? Yes, I think that was the situation for Boumediene. He was someone... he was not even captured in a war zone. He was arrested by Bosnian police and handed over to the USA, who would then detained for 7 years without any kind of trial. His lawyers as well made a habeas petition to federal courts, but in the initial ruling, lower courts held that because he's not a U.S. citizen and because he's being held in Guantanamo Bay and it's not really part of the United States, he has no right to a habeas petition. However, the Supreme Court had ruled in 2004 that basically Guantanamo Bay was part of the United States. From a very strict legal perspective, you might have some trouble with this. It seems as if the court is basically declaring part of Guantanamo Bay part of the United States. Why couldn't they have declared a military base in Normandy in World War II to be part of the United States? But from a realistic perspective, the United States is, exercised, all the forms of sovereignty over Guantanamo. So it was reasonable from that perspective. Okay, so what happened to Boumediene? Well, he challenged the process that he was part of, the combatant status review tribunals that had been established by the Bush administration. In this case, of course, Boumediene had been designated as an enemy combatant, even though the evidence seemed a little bit thin. He perhaps had been associated with Al-Qaeda agents. He had traveled to some terrorist hotspots around the world. Basically, he claimed that the combatant status review did not allow him the full ability to prove his case. It's somewhat convoluted what happens in this case, but essentially what happens is that the court rules that the 2006 Military Commissions Act, which sought to strip detainees of their habeas corpus rights, was unlawful. So what happens here is that this is a situation, according to Justice Jackson's framework for analyzing executive power, where the Bush administration was not merely acting on its own as the executive branch, but was acting with the authorization of Congress. And here the court said that no, you simply can't do that the act itself is unconstitutional. So this is a pretty significant example of how far courts are willing to go to restrain the executive, to restrain executive power in foreign affairs, even in situations where Congress has authorized the exception. So what we should note here is that the development of presidential power is not a simple story about the constant advance of presidential power. The restraints on executive power imposed by courts, particularly in recent years associated with the War on Terror, are in some ways unprecedented. Now, as I said, we can't fully explore the question of whether courts actually impose effective restraints on the executive branch. A Supreme Court decision is nice, a constitutional ruling is fine, but there's only so much courts can do to restrain the executive branch in practice. What we should note, however, is that these problems with executive discretion regarding domestic security, regarding foreign affairs, these aren't new problems, right? These aren't problems that have been invented because of the expanded power of the modern presidency. They've always been there, right? The problem of exceptional circumstances, that problem is an inherent part of politics. It's not something that's created by the modern world. And insofar as it raises constitutional problems, it doesn't raise new constitutional problems. Now, one area of presidential power which does raise, in some ways, potential constitutional problems, and certainly many political problems, is the power of independent presidential action. As I mentioned, executive power necessarily involves decisions about how to enforce the law. That involves discretion. That's unavoidable. But at what point does presidential discretion about how to enforce the law turn into presidential policymaking? The problem is that there's no precise legal line here. As the historian Thomas Macaulay once pointed out, there's simply a large no man's land between executive power and legislative power. When Macaulay was talking about this problem, he points out that the traditional power of the king to pardon wrongdoers, to pardon criminals, could, if used extensively, annul laws. Right? So that was an example of how a power that had been lodged in the executive could tread upon the legislative branch if the power was used ruthlessly enough. One thing that we can see is that in regards to presidents, in the modern era, they have moved across that in no man's land, pushing executive power onto the grounds of legislative power, in essence, exercising unilateral policy-making powers in more and more ways. But there are several different dimensions of this, as what's important to see is some elements of unilateral executive action are more problematic than others. We'll start with the least controversial aspects of unilateral executive policymaking that we can deal with relatively quickly. Certain kinds of executive actions that come through executive orders, basically just, as the term implies, orders from the president. There are certain kinds of orders from the president that simply deal with the internal management of the executive branch. And here the president is simply acting as the boss of the executive branch, telling his or her employees how to conduct themselves. Sometimes it can be relatively insignificant. I don't know. The president putting forward a rule that all employees of the Forest Service have to wear seatbelts or something like that. In some cases, executive orders of these kind can have important political implications or some symbolic significance, or just be very important in themselves. Here I'm thinking of President Truman's orders to desegregate various aspects of the military and the civil service. In general, though, these kinds of executive orders, they simply don't raise that many problems, whether political or constitutional. Considerably more controversial from both a political perspective and from a constitutional perspective are those situations where Congress enables unilateral presidential policy making. Some key examples here would be the National Industrial Recovery Act that was enacted by Congress during the Great Depression, and the bailouts, the TARP bailouts that occurred in the aftermath of the 2008 financial crisis, which I discuss a little bit in the ebook. These are situations where the legislative branch does not really create a law, but instead they more or less hand the executive branch the power and authority to ride forth and do good. The technical term, as I discuss also in the book, is the delegation of legislative power. And this raises a number of serious constitutional problems, or really one serious constitutional problem. From a theoretical perspective, you can make a reasonable claim that Congress cannot simply give the president the power to make law. Congress has been empowered by the Constitution to make law. It hasn't been empowered to make legislatures. The question is, how do you distinguish a unconstitutional delegation of power, delegation of legislative power, from a law that is just a little bit broad? In essence, the court has prevented Congress from delegating entirely unstructured power to the presidency, but they're willing to give the president a vast amount of discretion, or rather willing to give the executive branch as a whole a vast amount of discretion in terms of implementing the details of law. So in terms of the National Industrial Recovery Act, at first the court did apply the non-delegation doctrine, basically to prevent the national government from creating industry-wide production codes. So the courts did not allow Congress to simply hand these problems over to the executive branch without any direction. But subsequent developments would show that the courts, they didn't require all that much. They're willing to accept a considerable amount of delegated legislative power as long as Congress provides some kinds of general principles that can guide the executive branch. But one thing that we should note is that as Congress delegates this power to the executive branch, you can say that it's just delegating regulatory power or just delegating the power to create the details, and Congress has created the general principles. What we have to see is that when Congress delegates even this kind of power, even a constrained amount of legislative power, it enables the president, through the executive branch as a whole, to reshape the character of public policy without having to go through Congress. And this is it's really one of the reasons that control of the presidency has become so important in the modern era, understood here as, say, the post-New Deal era. We'll discuss this at much greater length in relation to bureaucracy when we reach Bureaucracy Week, but we should note some of the major issues right away. So, since the New Deal, Congress has created a large number of essentially regulation-generating machines within the executive branch. The Environmental Protection Agency, the Occupational Health and Safety Administration. You could go on and on and on. Presidents have the power to determine what those agencies do, and even though they can't reshape the fundamental underlying statutes that control these agencies, they can, for all practical purposes, shape how those agencies enforce the law, and they shape the rules that those agencies generate. Now, we should note, of course, that in most cases, presidents aren't necessarily involved in this directly. They operate, through their appointees. They're operating through the people that they place in positions in the executive branch who presumably are on the same team as the president, who share his or her mindset. They appoint people, presidents that is, appoint people who will share the same mindset so that they'll push bureaucracies in the required direction. The Reagan administration was quite notorious for this. Reagan used the Office of Management and Budget to constrain bureaucratic regulation by basically imposing very rigorous cost-benefit analyses on all bureaucratic rulemaking. And it was just a sign that if you create a giant national bureaucracy with laws that empower regulators but don't necessarily specify the details of regulation, then the meaning of law, the meaning of regulation, will change as presidential administrations change. And this is something that is very new and very modern and very distinct from the institutional arrangements established by the Constitution. It's also probably unavoidable, but nevertheless it is novel. What we should note that this is more of a change in Congress than it is a change in the presidency. This is more about a change that Congress initiated. Congress decides to exercise power in a different way. Congress, instead of defending its own institutional prerogatives, maybe it would be unable to defend its own prerogatives here given the public demands, but Congress chooses to grant this discretionary power to the executive branch. If Congress chooses to do this, if Congress chooses to abdicate its own power to craft detailed legislation, then it necessarily empowers the president. I want to return now to the question of presidential discretion about how to enforce law, and the question of when this unavoidable exercise of presidential discretion turns into a decision to annul or change the law. Now, this kind of a situation, presidents pushing their enforcement powers so far as to actually annul law or change policy entirely, is not particularly common. Much more common are situations where Congress has essentially granted and delegated power to the presidency, but it's considerably more controversial for obvious reasons. We can use a relatively recent example, President Obama's executive action on immigration reform from November 2014, sometimes referred to as DAPA, or the Deferred Action for Parental Accountability. Simplifying somewhat, in this action, President Obama granted deferred action status to millions of illegal aliens residing in the United States. The question is whether declining to enforce a law en masse is different in a significant way from, say, a police officer declining to enforce the speed limit for a few individual cases. As it turns out, there are indeed some important differences. Here, the president was not merely announcing that the law is not going to be enforced. He was trying to grant illegal aliens legal privileges that they had been denied by the established laws, whether wisely or unwisely. Congress had created barriers to prevent illegal entrants to the United States from gaining access to citizenship. And in particular, President Obama attempted to provide work authorization to illegal immigrants, something which obviously goes far beyond executive discretion. It's directly contrary to the established law. So, you don't have to look very far to find legal experts who will back up President Obama here, who will say that he's acting no differently than a cop on the beat, exercising their discretion, that there's absolutely nothing unusual about DAPA. But we should keep in mind the implication if that's true, and I think this is absolutely decisive as an argument against what the president is doing. If President Obama could do this, imagine what a President Rand Paul could do. Let's assume that Rand Paul still has the true religion of his father and he becomes president. And then he informs the nation, despite his inability to change the minds of Congress, despite his inability to change the tax laws through Congress, President Rand Paul announces that no one's going to be punished for failing to report their income taxes. All taxes are going to be purely voluntary gifts. Well, we can see that in this instance, there comes a point where presidential discretion about law enforcement crosses the no man's land and becomes presidential policy making. Now, in the case of DAPA, some courts have recognized this, and in response to state lawsuits, they've put in place an injunction to prevent DAPA from being enforced. So this is yet another example of the limits on the imperial presidency. The power of the president has expanded, but almost always when the power of the president expands, it's as a consequence of congressional authorization. It's difficult for presidential power to expand without the willing compliance in Congress, for better or worse.